Cartwell versus Burroughs. CARTMELL, I guess it is, isn't it? Juski, how much time do you want to reserve, if any?
5 minutes, Your Honor.
5 minutes, you got it.
Court, Annabelle Majeski, representing AMEE CARTMELL. As Your Honors know from our brief, we have 3 issues which we feel were reversible error and should have allowed the granting of a new trial. The first issue being the inclusion of a hearsay inadmissible report from Dr. Silbiger in the medical charts of Dr. Brzezinski, which was sent back to the jury room, and indication seems to be that they did consider it. The second being the admission of a photograph.
What are the indications that they actually considered it?
The fact that they awarded nothing, it indicated
EERC, from the result.
From the result, from the verdict.
There was no testimony that they had in fact considered it.
No, there's no testimony that they in fact considered it. Other than the one question that they sent back out, which goes to all 3 things. The defendant's theory basically was this was a very low impact rear-end collision. There's no way she was injured, and certainly not by developing a syrinx, which is what...
Well, I've been wondering how to say it.
Sharon. I think syrinx? Oh, I'm sorry, Your Honors. This is the trial attorney, David Gorwitz, who came up to keep me company. This is my first time here.
Won't be too hard.
So their main theory was this was a very low impact rear-end collision, that the plaintiff could not have been... I'm sorry, Your Honor.
Counsel, respond to the statement that's in the transcript that says if the jury looked at the report, which included Dr. Silbiger's report as well, they would know that that would not be a fact-based because there isn't anything here about causal relationship. If there's nothing in there about causal relationship, it seems to me it's just part of the medical records, and I'm having a difficult time trying to see how you all are prejudiced by that.
Well, basically the argument, I think during opening argument and certainly during closing argument, defense counsel kept saying that Dr. Brzezinski, which was Ms. Cartmell's neurologist, did not attribute her spinal injury to the accident until after he read Dr. Silbiger's report. That was their theory, and that's what he argued to the jury. And
but am I correct, though, in stating that nothing in Dr. Silbiger's report discusses causal relationship between this accident and any complaints that she might have about her condition?
Well, it's my understanding that he does say that it was caused by trauma, not genetics. Apparently, those are the 2 things you can it can be caused by trauma or it can be genetic. And it's my understanding that Dr. Silbiger attributed it to trauma, and the trauma that she suffered was the rear-end collision. Am I incorrect? Therefore, they were saying...
You turn and ask him if he's correct. Did you shake your head no or yes? Okay.
That's why they kept saying, look at Dr. Silbiger's report. He says that it was caused by the accident. But Dr. Brzezinski, who had already been treating her for a couple of years, didn't say that it was caused by the accident until after reading Dr. Silbiger's report. And he says, and you will be able to see that Dr. Silbiger's report is in Dr. Brzezinski's records. In other words, he was saying the fact that Silbiger's report is in Brzezinski's records proves what I'm telling you, ladies and gentlemen of the jury, that Brzezinski changed his opinion about the cause of the spinal injury after he read Dr. Silbiger's report. Until that time, he did not attribute it to the accident, And therefore, that just proves my point that it was low impact and she couldn't have been hurt this badly in the accident. That's why Dr. Silberger's report is damaging. Plaintiff's counsel kept saying Silberger's report is not in Dr. Brzezinski's medical records, but defense counsel kept saying, ladies and gentlemen of the jury, you'll have a chance to see the report and it will prove what I'm telling to you. And then it did turn out that Dr. Silberger's report was in Dr. Brzezinski's records, and therefore, after being told 3 or 4 times, ladies and gentlemen of the jury, go look at the medical chart.
Who introduced the records?
That I'm not sure. I think the medical records of Dr. Brzezinski were introduced by defense counsel.
Which included the report that you're
Which
talking about?
included Dr. Silberger's report, which had already been ruled hearsay and not admissible. I think the confusion, I don't want to be the one that's saying that was deliberate, because actually the case law says it doesn't really matter if it was deliberate or inadvertent.
But we're not going to.
Right. And there seemed to be confusion. Defense counsel inherited the case sort of at the last minute.
I was just trying to find out how it got in.
It got in the medical report. Dr. Brzezinski's medical records were introduced by the defense. Anyway, the case law says that if the jury considers that, extraneous materials that were inadmissible and that they shouldn't have, it requires a reversal. And the only way that you don't reverse on those grounds is if there is no possibility that they could have considered
Oh,
it.
no, wait, no. That's a criminal statute.
Oh, okay, I'm sorry.
That's not a civil statute.
I thought that that's what, excuse me one second. You're right, it is from King v. State. It is criminal. Well, then I guess we just decide whether the materials were of such a character as to have influenced the jury.
Yes, yeah, it is, and it's the person seeking the new trial's burden to establish that. I guess that's part of the difficulty that you have in this case.
Yes, Your Honor, and I know we also have an abuse of discretion standard.
Well, I guess for me at least, the critical issue is whether, I think everybody agrees that this was a piece of hearsay that got in, no matter how it got in, it got to the jury. And the critical issue is whether it made a bit of difference. And the argument seems to be that there's nothing within the document itself, if the jury in fact read it, which ties the injuries, the injury of the plaintiff to the automobile accident. It just says this is a traumatically induced injury. It doesn't say it's an injury caused by the auto accident.
Correct.
She may have done that riding a horse when she was 11 years old. I mean, I don't know what the situation is. So I guess that seems to me to be the point at which this whole debate revolves, and that is whether or not there was any serious prejudice resulting from that report. And I guess I would like you to address that if you
All
want.
right.
That goes to my original question about no causal relationship, so you can go answer Judge Monaco's question.
He attributes it to trauma and rules out genetic. But he doesn't, there is no direct evidence that says this was caused. Because, of course, if Dr. Silberger...
What do we do with that?
I guess we then take it in context with the other 2 errors as to see how badly they were influenced. Because the main thing seems to be here that all of these things contributed to the jury finding that it bolstered the defense argument that this was minimal impact. She couldn't possibly have all of these injuries just from a little tap in the rear while she's stopped, at an intersection. And that goes all...
They obviously bought that.
Yes. They obviously bought it, and because we've got, we've got the Silberger report sort of bolstering the defense, using that to bolster the argument that, Brzezinski treated her for several years, and he didn't say anything about, there's no indication in his records that this was caused by the accident. And then we have the photograph that was introduced of the defendant's car, which shows no damage to her car. And
You allege in your brief that was error, admitting the photograph.
because there was no predicate, there was no proper predicate, no one,
I thought the lady, the
Didn't the lady say?
defendant testified that it was an accurate representation.
well, she said, at the same time, she actually, basically, one of the main things that she said is she doesn't know when the photograph was taken.
But didn't she say there was a fair and accurate representation of the way the car looked right after the accident? Didn't she say that?
Well, she said she didn't know when it was taken.
I understand that.
But, so she said, I don't know when it was taken, that's the damage to my car. And then she's asked, well, didn't you have fender damage? And she said, yes. Well, that's not in the photo. Did you have, the bumper needed to be replaced? Yes. Well, there's no damage on this bumper. Well, there's no damage on that bumper, but that's the way it looked like before it got repaired.
That makes it admissible, and the rest of it is a matter of the weight for the jury to consider.
Well, that's what the judge ruled. But,
Why is he in error?
well, basically because we're saying, the judge ruled that way, I think mostly because he was impressed with the voir dire and the
Does
cross-examination.
that make it wrong?
No, it still goes to the,
I don't understand how that makes that error.
well, we're saying that,
It's a discretionary call on the part of the trial judge on a situation like that, and you've got to show us that he abused his discretion, which I think is
it's a
pretty
high
tall
burden
burden.
for us to meet, I know.
You know, I'm looking at Mr. Gorowitz's examination of her, and he beat her over the head with the notion that she didn't know when the pictures were taken and when the repairs were and how much the repairs were. I'm really having a hard time figuring out why that was error at all. I mean,
I guess basically we're trying to show that we felt that we should have, the photograph, the predicate to be laid should have been more specific as to exactly when the picture was taken.
but that's not the key.
And then,
The key is,
does
Does
it
it
show
accurately-
it was an inaccurate representation?
that's all it is.
Okay, and so you're saying, and we're saying, of course, we had evidence to show that it was not an accurate representation, but it was admitted anyway and say, okay, well, we'll let the jury decide on the weight of it.
Well, I mean,
And I guess we didn't really want to rely on the jury doing that when they're looking at a picture that shows no damage.
well, and Mr. Gorowitz asked her, when I took your deposition, you admitted there was front-end damage to that vehicle, right? Answer, yes. And you admitted there was $1,900 worth of damage to the vehicle, close to. Court, $1,885. $1,885, right? Right. Are you saying the picture reflects front-end damage? Yes, it does. You know, I mean, all of that information came to the jury, so, you know, don't we trust juries?
Yes. But we'd rather not have them looking at the photo in case they didn't remember Mr. Gorowitz's brilliant cross-examination.
Well, it was a very effective cross, I mean, honestly.
Yes, it was, and the judge complimented on him. The other thing was, we have the discussion about whether record custodian was needed for the repair estimates. And this goes back to, at the motions in limine, when one side wanted to have no one had a problem with the repair estimates coming in, with the authentication part of them. The problem arose because Mr. Borowitz wanted to explain that the person who had done the repair estimates worked for the insurance company and therefore was biased, and probably the estimates were a little low. This goes again to the fact that, of course, the more damage you have, that counterbalances the argument that it was a low impact.
But again, that's a discretionary call on the part of the trial judge to admit that statement in evidence, correct?
Well, what we have here is that there was a stipulation that no records custodians would be needed.
Well, not exactly. The stipulation was, as announced by Mr. Borowitz, we have agreed to waive all record custodians' trial testimony for medical and employment records while reserving all other objections. So unless this is a medical or employment record, there wasn't any stipulation.
No, but then later on during the arguments didn't seem, it seemed like everyone just assumed that the records, that they were authentic, and that the argument was that defense counsel didn't want the jury mention of who the persons who had done the appraisers worked for State Farm, and so he wanted that redacted. And that's where the argument came in and saying, well, okay, then now I want a records custodian. But I think finally the version that was going to be introduced by Mr. Borowitz was redacted.
Okay, so where's the harm if they already knew what there was an $1,885 estimate? I mean, why do they have to have a piece of paper if the testimony was?
I think he just wanted to then at that point introduce it to show, here's a photograph of the, he wasn't introducing it really to show that the damage was $1,800, of course, because that was their problem, how much damage was to her car. The significance of the report.
Down to 4 minutes time if you want to reserve 5.
Okay. But I'll just finish this thought. The significance of the repair estimate is sort of to impeach the photograph that had already gotten in, which showed very little damage, and then you can counterbalance that with the repair estimate that says the bumper was replaced, the fender was replaced, the hood had a dent, and the headlights were replaced. Thank you.
Good morning, Your Honor. May it please the court, counsel. My name is Catherine Anderson. I go by Katie. This is also my first time in law firm. Together with Nick Panagakis, we represent the defendant, Cynthia Burroughs Eford, in this case. I just wanted to touch on a couple of things that, before we get into the issues, specifically the standard of review. The standard of review, as announced by this court in DeWitt versus Maruhachi, and I hope I pronounced that correctly, is that there must be clear, the evidence must be clear, obvious, and not conflicting. And the appellant in this case has the burden to show that she was substantially prejudiced by either the inclusion of the photograph or the exclusion of the repair estimate, in addition to Dr. Stillberger's report. And in addition to proving that, the appellant has the burden of showing that that resulted in a miscarriage of justice. And the appellant is of the opinion that she would not be able to meet that burden in this case. Now, to touch a little bit on Dr. Stillberger's report, first of all, the defense in this case, denies that there was any intent to, put that report in evidence or perpetrate any type of fraud on the court. And if I could just explain briefly how this all came to be. We subpoenaed the records of Dr. Brzezinski. It was actually through the course of 4 different subpoenas. We subpoenaed them in the beginning, got all the records, and then we did 3 updates after that, so we got the updated records back. At the trial of the case, Mr. Borowitz sought to introduce the records from Dr. Brzezinski as well. However, based on the chart that we have, it was like 2 or 3 inches thick. It included not only the office notes, it included the narrative reports, the telephone messages, any letters in the file, things of that nature, which we felt needed to be shown to the jury as well. So we sought to introduce our own copy of Dr. Brzezinski's records as well. And it was within those records that we believe Dr. Stillberger's report was placed inadvertently, possibly by prior counsel, we're not sure, but it didn't.
You are admitting that they were not actually in Dr. Brzezinski's reports?
Well, what we believe happened was somehow that report...
No, answer that question first. Are you saying that they really should not have been in Dr. Brzezinski's reports?
We don't honestly know, Your Honor. I think what we can gather from Judge Moxley is that the report was found within the records of Dr. Brzezinski. The report itself was from their own expert. It was silent as to causation. Now, Dr. Stillberger testified at trial that the searings in Ms. CARTMELL's thoracic spine was related to trauma, but the report itself, the report that was actually, whether it was somehow inadvertently put in the records, was silent as to causation. But we believe that was...
Did it attribute the syrinx to trauma?
No, not in the report. In his testimony...
But not in his report?
That's correct, Your Honor. The report was silent as to causation. And the appellant in this case must prove, first of all, she says there was an indication that the jury reviewed it. We don't have any evidence to suggest whether or not the jury even, went through the records. It seemed pretty quickly that they started going through the verdict form because the first questions that came up had to do with the verdict form. So we can't even say for certainty that they even looked at any of the records. And the appellant in this case has the burden of proving that this inclusion of this report, whether inadvertent or through any other error, was material, and there was a manifest injustice to the plaintiff. Now, Judge Moxley looked at the report. He agreed that the report was silent as to causation. And the cases that the plaintiff cites in her case, specifically the Keene case, which is a criminal case, Brooks, the Harris case, and the CYNTHIA case, I hope I pronounced that, are all distinguishable in the facts, and if you like, I could go through those individually. As to the photograph, I think we're all in agreement that Cynthia Burroughs testified and properly authenticated the photograph of her vehicle. I would disagree with appellant's counsel that she didn't know the date that the photographs were taken. Indeed, she did not know the exact date, but she testified that the photographs, and she was certain of this, that they were taken after the accident and before the repairs were made, because she had taken a visit down to the shop. She had a relative in the business, and she knew that the first thing that happened to that car was that the bumper was taken off and the bumper was still on the car. So that was based on her representation that the photograph was a fair and accurate representation of her vehicle. Any discrepancy, whether or not there has been some allegations that the photograph was somehow doctored or was not a fair, accurate representation of the damage, that goes to the weight of the jury, as Judge Moxley correctly determined. I think we're all in agreement that Mr. Borowitz had quite an effective cross-examination of Ms. Burroughs in that case. And after he cross-examined her, he published the interrogatory answer outlining the amount of damage to her vehicle. And incidentally, there was approximately about $500 worth of damage, $600 worth of damage to Amy CARTMELL's vehicle. As to the repair estimate, there was a motion in limine based on the fact that the repair estimate had State Farm's heading on it. And based on the non-joiner statute, we sought to redact that portion of the estimate to take out any reference to insurance, any reference to State Farm. That was what the motion in limine was about. There was no stipulation. I think that's evidence in this case. There was no stipulation. We knew that based on Mr. Panagakis' experience from the previous case and the BLN versus State case, that an appraiser needed to testify to properly authenticate the repair estimate. And we had those people listed. We had them prepared to testify. However, it was our error because we didn't list them as experts on our witness list, that they were excluded from testifying at trial. So we had prepared to call them to testify to that. And again, Mr. Borowitz published the interrogatory answer to the jury pretty much right before they were getting ready to retire, which disclosed the amount of the property damage to Ms. Burroughs' vehicle. Now, I think it stands to reason that, Mr. Borowitz had testified, or not testified, he had stated that in the past he had some problems with insurance companies doctoring estimates. We're unaware of that. We don't believe that there's any proof to that. But I think it stands to reason that if he has a history of repair estimates being doctored, and he's concerned about the photographs not showing the proper damage, that he would bring in a property damage estimator to testify, some sort of expert to testify as to the amount of property damage, and that he didn't do that in this case. He made a tactical decision not to do that. So we are asking that the court affirm the opinion of the lower court of Judge Moxley, who is a senior trial judge who listened to, this was pretty much a 4 or 5 day trial. He listened to all the evidence. He read the lengthy briefs by the attorneys in their motions for a new trial. He listened to over an hour and a half worth of argument, and he determined that This was a fair trial, it was a fair result, and we're asking for the court to affirm his opinion.
Thank you, counsel. You only got 3 minutes and 45 seconds.
Actually, Your Honors, I did not.
Have you made a notice of appearance in this case, Mr. Rhodes?
I believe I'm on the appellate brief, Your Honor.
If not, you need to make one.
I just wanted to clarify a few things, Your Honor. Number one, if you take a look at the record on page 4 and on page 803, Mr. Panagakis himself, the trial lawyers, conceded that we had agreed to waive all record custodians. It was not only waiving record custodians as to the medical records and employment records, it was waiving all record custodians, and the court can take a look at page 4 and page 803. It was only when I attempted to introduce the repair record that the first objection to authenticity came forward. The jury had the photographs. They did not have the invoice or the repair record, and they may have been speculating why. Why do we have one? Why do we not have the other? Maybe the court decided that the other one was not reliable. There's no way of knowing. Number two, we took a post-trial deposition of Dr. Krasinski. The medical record, the expert report, was not part of his medical records. The expert report had never been provided to Dr. Krasinski. And the expert report was damaging not only because it helped to bolster the defendant's position, but if you take a look at the expert report, it also minimized the injury to my client. It talked about minimal bulging discs and so forth. So there was a lot of things in that medical report we did not want the jury to see, and it was not part of the record. If the court takes a look at the post-trial deposition of Dr. Krasinski, that will be clear to the court. With regard to the issue of
Did Dr. Silberger testify?
Yes, sir.
Well, why couldn't it have been introduced through him?
Well, first of all, expert reports are not admissible, as the court well knows.
Oh, but he could have been cross-examined on the basis.
He was not cross-examined by the defense at that time regarding the minimal bulging discs. They never asked him those questions. They could have, but they did not. That was not part of his testimony. And
how many times during closing argument was the reference to the report made?
It was made in the opening statement, and that was made again in the closing argument. I can't tell the court how many times because I was not prepared to argue today, but it was made very persuasively by defense counsel. I immediately moved for a mistrial at that point, and then moved again I again asked after the close of the evidence, or before the evidence was submitted, I told the judge, Your Honor, that was not part of the evidence. And the court looked at Mr. Panagakis and said, Mr. Panagakis, was that expert report part of the medical records? And Mr. Panagakis looked at Judge Moxley and said, absolutely, Your Honor, these medical records came in completely unedited. Nothing about, well, I'm not sure, Your Honor, because I came late. He made an affirmative affirmation to the trial court that those records were medical.
In the record?
Absolutely, it is, Your Honor. It is in the record. And I believe it was pointed out by appellate counsel in her oral argument. So there were negative comments in that medical expert report, which Mr. Panagakis obviously wanted the jury to see. If the court takes a look at the photograph of this car, this looks like it came off of a new car lot. Now, I understand what the defense counsel, or what the defendant testified, but her testimony did not establish, or completely was contradicted by the repair estimate, which is why that repair estimate was so important to go into evidence per the pretrial stipulations. And I just wanted to make all that clear to Your Honors. I guess I may well be out of time, but the
Counsel, your time, Mr. Conner.
Okay, thank you, Your Honors. And I appreciate you letting me.
Thank you. Court will be adjourned.